afternoon, everyone. Can you hear me? Yes, that's great. We've been having occasional issues with technology, so I just want to make sure that everybody can hear me. Thank you for coming. My name is Sophia McCardle. I'm with the Office of Post-Secondary Education Policy, Planning, and Innovation. And today I'm going to be presenting a regulatory update on the TEACH grant program and also touch on what we're calling the faith-based entities provisions. It's kind of a very full presentation, and I'll try my best to leave time for some questions at the end. So, in 2007, just to give some background context, Congress established the Teacher Education Assistance for College and Higher Education Grant Program, which everybody calls the TEACH Grant Program. The purpose was to help increase the number of teachers teaching in high-need fields and in low-income schools. It's a non-need-based program that provides up to $4,000 per year to students enrolled in a TEACH grant eligible program who agree to teach as a highly qualified teacher in a high-need field at a low-income elementary or secondary school for 4 years within 8 years of completing the program. If a student fails to complete the required teaching service, this will result in the conversion of the TEACH grant to a federal direct unsubsidized loan with interest accruing from the date the grant was dispersed. So, the standardized running joke, everybody's heard it, is that this is neither a grant or a loan, but a groan. Grants are provided up to $4,000 per year for the first undergraduate degree or post-baccalaureate credential, up to an aggregate of $16,000, $4,000 per year for a master's degree, up to an aggregate amount of $8,000. We do prorate grants for less than half time, and the amount of TEACH in combination with other assistance may not exceed the cost of attendance. Who can apply for TEACH? Undergraduates, graduate students pursuing a master's degree but not a doctorate, students enrolled in a post-baccalaureate teacher credential program, current or former teachers, and retirees. With regard to student eligibility, applicants must meet the general provision student eligibility requirements 34 CFR 668 subpart B. They have to complete a submitted completed FSA. So even though this is a non-need-based grant, the FAFSA does serve as the application, and we will talk about this issue a little bit later when we talk about negotiated rulemaking. Students also sign an agreement to serve, enroll in the TEACH grant eligible program, be completing or intend to complete coursework necessary to begin a career in teaching, and not already have earned a first bachelor's or post-bac. There is a required academic achievement requirement for undergraduate, postgraduate, and graduate students, a cumulative GPA of at least 3.5 from high school if you're a first-year undergrad or postgrad student, or from the first semester of college, which means you wouldn't have gotten it then. College or post-baccalaureate coursework GPA for undergraduate and postgraduate students beyond the first year, college GPA for a first-year graduate student or first semester GPA for a graduate program, and then graduate coursework beyond the first year. Or you can skip all of the above and just score above the 75th percentile on one of the batteries of a nationally normed admissions test, such as an ACT, CAT, SAT, GRE, whatever is appropriate. There is an exception to the academic requirement for a current or a former teacher or retiree who is applying for a grant to obtain a master's degree or is or was a teacher who is pursuing certification through a high-quality alternative certification program. Regarding Institutional eligibility. An institution must be a Teach Grant eligible institution in order to disperse Teach Grants. To be a Teach Grant eligible institution, an institution must apply to participate in a Teach Grant program and be approved by the Secretary. The application is the EAP. In addition, the institution must meet other requirements, including being financially responsible in accordance with 34 CFR 668 subpart L, or meet an alternative standard, and also meet one of 4 additional eligibility requirements. First way to establish institutional eligibility under the additional requirements is to provide, by the institution to provide a high-quality teacher preparation program at the bachelor's or master's degree level accredited by an agency specializing in professional teacher education programs, or be approved by a state and include at least 10 weeks of full-time pre-service clinical experience and assist in providing pedagogical coursework. The school must also provide or assist in providing supervision and support services to teachers, such as identifying and making available information on effective teaching skills or strategies, identifying and making available information on effective practices in the supervision and coaching of novice teachers, and mentoring focused on the development of effective teaching skills. Second way would be to provide a 2-year program acceptable for full credit in an eligible bachelor degree teacher preparation program, or be acceptable for full credit in a high-need field offered by a Teach Grant eligible institution, and be able to demonstrate that relationship. Third way would be if an institution offers a bachelor's degree that in combination with training or experience will prepare students to teach in a high-need field, and it's entered into an agreement with an eligible institution that offers a high-quality teacher preparation program, or one that offers a post-baccalaureate program. An institution can also provide a post-baccalaureate program of study that does not lead to a graduate degree, consists of courses required by a state for professional certification or license to teach in an elementary or secondary school in that state, and is an undergraduate program for Title IV financial assistance purposes. So there's one other little piece here that's kind of important to keep in mind, which is Teach Grant program eligibility, as opposed to institutional eligibility, as opposed to student eligibility. Teach Grant eligible institutions have a lot of latitude to designate which programs they want to make Teach Grant eligible. Programs must be designed to prepare an individual to teach as a highly qualified teacher in a high-need field and lead to a bachelor's or master's degree, or be a post-baccalaureate program. A post-baccalaureate program is not a Teach Grant eligible program at institutions that offer both a post-baccalaureate degree and a bachelor's in education. Is a statutory. Everybody always asks about this, but it is statutory. And a 2-year program of study that is acceptable for full credit towards a bachelor's degree is considered to be a program of study that does lead to a bachelor's degree. So what are the high-need fields? These are statutorily distinguished as mathematics, science, foreign language, bilingual education, and English language acquisition, special education, reading specialist, and other high-need fields documented by local, state, or the federal government. And with respect to the other high-need field, for our purposes, states report these annually to the department as their teacher shortage areas, and we will talk about this a little bit later. Current teach counseling requirements, well, they have to provide initial, subsequent, and exit counseling to students. And as noted before, there is a service obligation requirement for TEACH. The agreement to serve obligates the grant recipient to teach full-time as a highly qualified teacher in a high-need field at an eligible low-income elementary, secondary school, or educational service agency for at least 4 academic years. Complete those years within 8 years of completing or otherwise leaving the Teach Grant program of study, and certify that within 120 days of completing or otherwise leaving the Teach Grant program and each year thereafter that they are meeting or intend to meet the service obligation requirements. It turns out that this certification within 120 days piece is very, very problematic, and we will get back to this later. Again, we're still talking about the current requirements to provide the context for what happens next. A couple other things to note. Service obligations can be suspended for Teach Grant recipients who have completed or ceased enrollment and can be discharged if the recipient dies or becomes permanently and totally disabled. So, why are we doing all this? In 2007, as I indicated before, this program was established to help increase the number of teachers in high-need fields and in low-income schools. However, a 2015 Government Accountability Office report found that 36,000 out of more than 112,000 Teach Grant recipients had not fulfilled their Teach Grant requirements and had their grants converted to loans. There were some other findings, but regardless, the GAO bottom line concluded that the department should better understand the reasons teachers do not meet program requirements, and program management should be improved, especially with respect to the grant to loan conversions. So, in 2018, a study was done for the department by the American Institutes for Research, some of you know that this is just AIR, and found that as of June 2016, 63% of Teach Grant recipients who started their 8-year service obligation before July 2014 had their grants converted to unsubsidized loans because it did not meet the service obligation requirements or the annual certification requirements. The factors that were associated with recipients not meeting grant requirements included those related to the recipient's employment, including teaching in a position that did not qualify for the Teach Grant service obligation, not working as a certified teacher, the recipient not understanding the service obligation requirements, and factors to the recipients providing the annual certification, not providing the annual certification because the recipient did not know about the annual certification process, and not providing certification because the recipient experienced challenges related to the certification process. So, given all these issues and sort of the spotlight on this whole conversion process, one of the things that happened was that the department established this negotiated rulemaking committee that we've already discussed in other sessions before, the Accreditation and Innovation Committee, and conducted this rulemaking from January to April 2019. There were 3 subcommittees formed to inform that committee, and one of these was the one related to the Teach Grants, and the second one was related to faith-based entities. And the third one would have been the Distance and Educational Innovation Committee. The buckets of issues were there were 3 buckets, even though there were sort of like really 4 groups. It really came down to 3 buckets, where the Teach Grant program and the faith-based entities proposals became a bucket. So, consensus language. What is this? What it is that there was language that the negotiating committee reached consensus on regarding the Teach Grant program, and this, as well as the faith-based, but right now we're talking about Teach, and the proposals that we're talking about here will be reflected in a notice of proposed rulemaking which we expect to publish very soon. So when these are published, they will become actual formal proposals at this point, and the public will then be invited to comment on the formal proposals. And in addition, for the Teach Grant program in particular, there's a lot of forms that are associated with administering this program. So there will also be an opportunity for the public to comment on the updated versions of these forms. So this hasn't happened yet, sort of like what we were talking about in some of these other groups, where there's one final regulation with respect to this negotiated rulemaking that already came out, which dealt with accreditation and state authorization for distance education. And then there's a couple pieces I'll talk about with faith-based coming down the road. But the language that I'm going to discuss now, this constitutes the consensus language that came out of the negotiated rulemaking. So I'm just going to say this now, and I'll say it again later. With respect to discussing this in terms of getting questions and whatever, we cannot entertain comments yet on these because we have not done the official notice of proposed rulemaking, which is the official opportunity for the public to comment on these proposed, at that time when they're in a notice of proposed rulemaking, their proposed regulations. The conversation we'll be having today will involve the consensus language that came out of the negotiations. So I just want to make that clear. I'll make it clear multiple times because this is actually, just as an aside, it's unusual that we're in this kind of situation because normally there's one or the other published. So I want to keep making that clear that there is a very clear distinction on what goes on with these particular consensus language proposals. So let's just chat a little bit. It's kind of in a big picture what we're trying to do here. For Teach, we have proposed consensus language that will ultimately simplify the Teach Grant program requirements and would then update, strengthen, and clarify other areas of the Teach Grant program regulations, which would minimize the number of Teach grants that are converted to federal direct unsubsidized loans. For the faith-based, we have proposed language by which we will revise the current regulations regarding the eligibility of faith-based entities to participate in Title IV programs and the eligibility of students to obtain certain benefits under those programs. Most of this presentation will focus on the Teach Grants program, and I know even though that'll be a broad overview, it'll be an even broader overview for the proposed language, consensus language for the faith-based entities for this conversation. So again, when I say that, that means we won't be looking at every single proposed consensus language piece, but try to give you a sense of what's coming, because it's coming. So, for the Teach Grant program consensus language proposals, there are some very general changes that were made throughout the consensus language. First, we added references to Educational Service Agency as appropriate because this reflects a change that was statutory change that was made with the Higher Education Act of 2008, which included education service agencies in a description of a low-income school for the purposes of Title IV student assistance programs, including Teach. And further, in the consensus language, we proposed to change the name of the agreement signed by a Teach Grant recipient from Agreement to Serve, which you all are used to Agreement to Serve or Repay, to clarify that the agreement requires the Teach Grant recipient to commit to meeting the service obligation or repay the loan. The current term obviously does not exactly convey the consequences for failing to meet the service obligation requirements. And this change then would clarify that signing the agreement to serve or repay commits the Teach Grant recipient to do one or the other. And then we also provide references to the direct unsubsidized loans for consistency with terminology used in the direct loan program regulations. Further, for consistency with proposed changes that I'll be talking about in a little bit more detail later, in the consensus language, we amended 686.1. This is scope and purpose, to state that the 8-year period for completing a service obligation begins when a student ceases enrollment at an institution where he or she received a Teach Grant, rather than when the student completes the program of study for which the student received the grant. Furthermore, because the current Teach Grant regulations do not address the starting date of the 8-year service obligation period for students who receive a Teach Grant at one institution and then later transfer to another institution, the consensus language clarifies that in such cases, the 8-year period would begin when the student ceases enrollment at the transfer institution. And again, this would be consistent with other changes that we make that will associate all Teach Grants received while the recipient is at the same academic level. So we talked about adding some definition already to the 686.2, which is where the Teach Grant definitions live. One being the educational service agencies, and we defined those as a regional public multi-service agency authorized by statute to develop, manage, and provide services or programs to local education agencies. And we also added teacher shortage area listing nationwide list. Neither the Higher Education Act nor the current regulations define this teacher shortage area nationwide listing. So we're proposing to add this definition as a list of teacher shortage areas in each state as defined in 34 CFR 682.210 Q8 Romanet 7. So these regulations actually refer to the targeted teacher deferment regulations under FEL. And under there, there's a definition of teacher shortage area, which means an area of specific grade, subject matter, or discipline, classification, or a geographic area in which a secretary determines that there is an inadequate supply of elementary or secondary school teachers. So you can see how all of this then relates together when you look at it that way. So those were things we added. Then that we have things that we are revising. We talked already about revising agreement to serve or repay. And we also are replacing the current definition of highly qualified with the full text of the statutory definition and adding provisions that describe how a public or nonprofit private elementary or secondary school teacher who is exempt from state certification requirements can meet the highly qualified requirement. So the reason we're doing all of this is that the Every Student Succeeds Act, known as ESSA, removed the highly qualified term definition from the law for ESEA purposes. However, there was a section in the ESSA that provided that for purposes of Title IV, HEA federal student aid programs, including the Teach Grant program, the term highly qualified, as it was defined in the Elementary and Secondary Act, as of the day before the enactment of the ESSA, continues to apply. So that means the Teach Grant recipients must still meet the highly qualified standards to satisfy their service obligation. To clarify this that the highly qualified teacher requirements continue to apply for purposes of TEACH, and to ensure that grant recipients understand this, because it is actually very confusing when you have these two different things that seem to be in conflict with each other. The consensus language provides this information in its entirety, the definition of highly qualified in its entirety in the regulation. However, this definition does not address private school teachers. And teaching in a qualified nonprofit private school can be qualifying service for a TEACH grant recipient. So to clarify those requirements for private school teachers and to be consistent with requirements that apply to teachers seeking other loan forgiveness in direct loan and FFEL programs, we expanded that definition to include language that describes how private school teachers who are exempt from state certification can meet the highly qualified requirement. This is a whole lot of stuff just to say this is why it's in here, because people are questioning why would the consensus language have this, and it is ultimately to keep people from getting confused and to make it clear what others can do that are not in the highly qualified world. We also amended schools serving a low-income students, a low-income school for short, to be an elementary school, secondary school, or educational service agency listed in the department's teacher cancellation low-income directory. However, all elementary and secondary schools and educational service agencies operated by the Bureau of Indian Education in the Department of Interior, or operated on Indian reservations by Indian tribal groups under contract or grant with the BIE will qualify as schools or educational service agencies serving low-income students. Last but not least, we propose to add language to the current definition of a TEACH grant eligible program to state that a TEACH grant eligible program is a program of study at a TEACH grant eligible institution. So this makes it clearer that if an undergraduate student, an undergraduate TEACH grant recipient, transfers to a different institution prior to completing the program for which they received their TEACH grant, and then enroll in the bachelor's program at a new institution that could qualify as TEACH grant eligible, the recipient would then be eligible to have the starting date of the 8-year service obligation period adjusted only if the new institution participates in the TEACH grant program. So this is just more clarifying things that we did for this program to make it easier for students. There was consensus language proposals to amend 68.10 and 11, which deal with the application, and to add that we are modifying 6.10 and student eligibility requirements of 6.11 by replacing references to submitting a TEACH grant application with references to submitting the FAFSA and making additional changes. There simply is no other application for the TEACH grant program, and yet we kept referring in the prior regulations to another application that simply never existed and won't exist, because now we are going to be planning to continue to use the FAFSA. A lot of changes were proposed as part of the consensus language for the agreement to serve. We already talked about the change in the title. There's expanding the description for the contents of the agreement to serve or repay. There are going to be clarifications of requirements for completion of more than one service obligation, adding language to explain the service obligation requirements for recipients who withdraw from an institution before completing the program for which the TEACH grants were received and then they later re-enroll. updating conditions under which a teach grant recipient might satisfy the service obligation by teaching in the high-need field listed in the department's nationwide list. So, to get a little bit more specific on this, in the contents of the agreement to serve or repay, in the consensus language, we're proposing that to specify that in the 8-year period, that the 8-year period for completing the service obligation will begin on the date the grant recipient ceases enrollment at an institution or at the transfer institution where he or she received their grant, rather than on the date the recipient completes or otherwise ceases to be enrolled in the program of study for which the recipient received the grant. We are also proposing that a grant recipient must complete one service obligation for all teach grants received for undergrad study at the same institution or at more than one, or one service obligation for all teach grants received for graduate study at the same institution or at more than one institution. So this was very helpful from the consensus language. We also felt that it was important that each service obligation begins when the grant recipient ceases enrollment at the institution where the teach grants were received, or in the case of a grant recipient who receives a teach grant in one school and then transfers within 8 years from the date the recipient ceases enrollment in the other institution. For a teach grant recipient who withdraws from the institution before completing a bachelor's or a post-baccalaureate program for which they received the grant, but then later they re-enroll in either the same or a different baccalaureate or post-bac program in a different teach grant eligible baccalaureate or post-baccalaureate program before the date their grants are converted to loans, direct unsubsidized loans, and they receive additional teach grants, or the Secretary otherwise confirms that the teach grant recipient has re-enrolled in the teach grant eligible program. The Secretary then adjusts the starting date of the period for completing the service obligation to begin when the recipient ceases to be enrolled at the institution for which he/she has re-enrolled. And that would apply whether or not they are a master's degree or a bachelor's degree student. In the case of a teach grant recipient who's covered under these sections, who completed one or more complete academic year of credible service, as we've described during the period between the grant recipient's withdrawal and re-enrollment, the Secretary would not adjust the starting date of the period for completing a service obligation unless the recipient requested this, and the completed teaching service would count towards satisfying the grant recipient's service obligation under C2 of this section. If the grant recipient continues to perform creditable teaching service after re-enrolling, the grant recipient may receive credit towards satisfaction of the service obligation for any complete academic years of creditable teaching performed while the recipient is concurrently enrolled in the teach grant eligible program, only if the recipient does not request and receive a temporary suspension of the period for completing the service obligation under 6.41. So let's switch gears a little bit. For a grant recipient teaching service in a high-need field listed in a nationwide list to count towards satisfying the service obligation, the high-need field in which he or she is prepared to teach must be listed in the nationwide list in which the grant recipient teaches for service performed before July 1, 2010, at the time the grant recipient begins teaching in that field, even if that field subsequently loses its high-need designation for that state, or for teaching service performed on or after July 1, 2010, at the time the grant recipient begins teaching in that field, even if that field subsequently loses its high-need field designation for that state, or at the time the grant recipient signed the agreement to serve or repay, even if the field subsequently loses its high-need designation for that state before the grant recipient begins teaching in that field. So this is just to make it easier and clearer for the grant recipient to be able to continue doing what they were doing. We also have consensus language related to changes to initial, subsequent, and exit counseling. All three must explain that to avoid further accrual of interest, as we would describe in 68612B4II, a grant recipient who decides not to teach in a qualified school or field, or who for any other reason no longer intends to satisfy the service obligation, may request that the Secretary convert his or her grant to a direct unsubsidized loan that the grant recipient may begin repaying immediately instead of waiting for it to be converted to a loan. And if the grant recipient does request this, then that loan cannot be reversed. So the reason that you would want to do that is you don't want to continue to do this, and instead of waiting and accruing interest, you just start paying back earlier. It saves the student money. It's a very clear financial gain to the student to do it that way. They all would have to also emphasize that once a teach grant was converted to a loan, it can only be reconverted if the Secretary determines that the grant was converted to a loan in error, or for a recipient whose teach grant was converted to a direct unsubsidized loan in accordance with something we haven't discussed yet, but we will. Within 1 year of the conversion date, the recipient provides documentation showing that he or she is satisfying the service obligation within the 8-year service period. For initial and exit counseling specifically, there's consensus language indicating that the initial and exit counseling must inform the grant recipient that we're teaching to count toward the recipient's service obligation. The high-need field in which he or she is prepared to teach must be one of the 6 high-need fields we list in 686.2, or a high-need field that is listed in the nationwide list in which the grant recipient teaches at the time the recipient begins teaching in that field, even if that field subsequently loses its high-need designation for that state, or for teaching service performed on or after July 1 at the time the grant recipient signed the agreement to serve or repay or receive the teach grant even again. So you can see this consistent pattern where we're adding these same pieces to different parts of the consensus language. Specific consensus language related to exit counseling says that the exit counseling must review the terms and conditions of the teach grant agreement to serve or repay and emphasize to the grant recipient that the 4-year service obligation must be completed within 8 years. Emphasize to the grant recipient that if the grant recipient fails or refuses to complete the service obligation, then the teach grant must be repaid as a direct unsubsidized loan, and the grant recipient will be obligated to repay the full amount of each grant and accrued interest from each disbursement date. Explain the treatment of a grant recipient who withdraws from and then re-enrolls in a Teach Grant eligible program at a Teach Grant eligible institution. And explain to the grant recipient that the secretary will, at least annually during the service period, send the recipient a notice that we will describe in a different section. Now, there's an important piece that's not on here, but I want to emphasize this because it's something we are proposing to remove. And what we're proposing to remove from exit counseling is the requirement that will be also discussed when we discuss point 43, that eliminates the requirement for recipients to annually provide the secretary with documentation of their progress towards satisfying the service obligation or notice of their intent to satisfy the service obligation. So that was previously part of the counseling that we are no longer going to be including in this counseling. We are proposing something completely new, and it is called new conversion counseling. So the idea here is that when a student is a student and they're a grant recipient, they are not a borrower, but once they become a student for which there was a conversion of their grant to a loan, they are now a borrower. So at the time of the conversion, the secretary would conduct conversion counseling with the recipient using interactive electronic means or mailing written counseling materials to the recipient's most recent address to mirror direct loan exit counseling requirements, but have those be relevant to teach, and the proposed consensus language regulation would include all elements proposed to be removed from the current exit counseling. There are some differences that will be existing in the new proposed consensus language exit counseling, where the borrower would be informed of the average anticipated monthly payment based only on the borrower's indebtedness, not also on average borrower indebtedness. And loan forgiveness options discussed would specify public service loan forgiveness specifically, explain the availability of public service loan forgiveness and teacher loan forgiveness, and explain how a borrower may request reconsideration of the conversion of the Teach Grant to a loan if the borrower believes the grant was converted to a loan in error. All of these, again, had consensus language. We would also inform the borrower of the grace period and the amount of interest that had accrued on the converted Teach Grant, with an explanation that any unpaid interest will be capitalized at the end of the grace period. There were a lot of changes in point 4.0, documenting the service obligation, and this is, again, where the Teacher Grant Program ran into some issues earlier. This is part of what I was mentioning before, where we have consensus language to remove the requirement for recipients to confirm their status within 120 days of ceasing enrollment in a program for which they received a Teach Grant. Basically, we felt this is unnecessarily complex, and it basically just confuses things with documenting the service obligation. We would eliminate the current provision that a grant recipient may not satisfy the service obligation by teaching in a geographic region of a state or in a specific grade level not associated with the high-need field designated as a teacher shortage area in the department's nationwide list. So the goal of the Teach Grant Program is to encourage teachers to accept positions in low-income schools where there is an urgent need for teachers. in high-need fields, but in many parts of the country, there's an urgent need for teachers because there's a general shortage of teachers in specific geographic regions, such as rural areas, or in certain grade levels, without regard to the subjects that are being taught. So there may be an urgent need, for example, for elementary school teachers in a rural part of a state. Before this change that we received, that is part of this consensus language, you would not be able to do this type of teaching and have that teaching count as towards your service obligation. But now, under this new consensus language, a student would be able to take advantage of this. And so by eliminating the current regulatory requirements, the consensus language enables more grant recipients to teach where there essentially is the greatest need for teachers under this piece. We would also add that in the consensus language that residing in or being employed in a federally declared disaster area to be another condition that would allow less than a full year of teaching to count towards satisfaction of the service obligation. And this was because it was felt that the grant recipients who teach for part of an academic year, but who are unable to teach for the remainder of an academic year as a result of their home or their place of employment being adversely affected by a natural disaster, should receive credit for the partial year of qualifying teaching that was completed, assuming they meet all the other qualifications that are required. And we also propose to amend the periods of suspension by adding that a grant recipient may receive a temporary suspension of the period for completing the service obligation while receiving state-required instruction or otherwise fulfilling requirements for licensure to teach in a state's elementary or secondary schools. There may be cases in which a grant recipient who is certified to teach in one state may move to a different state and then be unable to teach in that state until they receive whatever the state-required instruction is, or otherwise fulfill requirements for state licensure in that state. And so to ensure that they would be able to complete the required 4 years of teaching within that 8-year period, this could be another suspension that a recipient could take advantage of in order to have the ability to complete their service obligation. Another new suspension would be based on military orders for the recipient's spouse in deployment with a military unit or as an individual in support of a call to federal or state active duty or active service, or a change of permanent duty station from a location in the continental United States to a location outside of the continental United States, or from a location in a state to any location outside of that state. And in general, there is the new suspension of being able to receive a suspension due to residing or being employed in a federally declared major disaster area, as we've defined in other disaster information under the Robert T. Stafford Disaster Relief and Emergency Assistance Act. The committees all felt that there could be some unforeseen other circumstances that could temporarily prevent a grant recipient from fulfilling a service requirement, and therefore recommended adding this provision, which allows on a case-by-case that the Secretary can grant a temporary suspension of completing the service obligation if the Secretary determines that the recipient was unable to complete a full academic year of teaching or begin the next academic year of teaching due to exceptional circumstances significantly affecting the operation of a school or educational service agency where the grant recipient was employed or the grant's recipient's ability to teach. I believe one example that came up during this situation was like an airplane crashing into a school, which would make it very hard to teach at that school. So that would be something that would qualify, for instance, probably under this case-by-case scenario. And to ensure that the recipients are informed of the status of the application for suspension, we propose specifying in the regulations that the Secretary would notify the grant recipient regarding the outcome of an application for suspension. Now, I just want to also note, like, I'm talking about these forms, so when a notice of proposed rulemaking comes out and you have an opportunity to look at these forms, these are the kinds of forms I'm talking about, where these are the changes that we're making these, that we'll be making to these forms. You will see these kinds of changes show up. We also got consensus language on proposing to amend 686.42, which is the discharge of the agreement or serve to repay, by updating the requirements and procedures for receiving a discharge of the teach grant service obligation based on a total and permanent disability. The current regulations with respect to this are modeled on direct loan TPD discharge regulations that were in effect when the original teach grant regulations were issued. Since that time, on November 1, 2012, final regulations were published that made significant changes to the regulations that dealt with TPD discharge processes in the direct loan FFEL and Perkins loan programs. And so as a result, the language related to that in 686.42b is obsolete, and therefore we are proposing to amend this. There are also major changes that were proposed in the consensus language for 686.43, which is the obligation to repay the grant. Here, what I want to say is there are different circumstances that result in conversion of a teach grant to a loan depending on whether the recipient did or did not complete the program of study for which he or she received the grants. And in addition, under the current regs, the recipient can be subjected to loan conversion if the recipient fails to meet certain certification requirements within specified timelines, even if the recipient is otherwise meeting the service obligation requirements. This is one of the things that was brought up over and over again as a concern regarding the teach grant programs. Our experience in administering a teach grant program has shown that the existing current regulatory conditions for converting teach grants to loans are difficult for recipients to understand, and in some cases have led to conversions of grants made to recipients who are performing qualifying teaching services but who failed to meet certification deadlines. So, to simplify program requirements, reduce burden on recipients, and minimize a grant-to-loan conversion resulting from late submissions of documentations, we are proposing, through the consensus language that came out of the negotiated rulemaking, to retain with minor modifications only the current regulations that provide for loan conversion if the recipient requests the conversion or if the recipient fails to begin or maintain qualifying teaching service within a time frame that would allow the recipient to complete the required 4 years of teaching within an 8-year service obligation period. These provisions would apply to all grant recipients, regardless of whether they complete the program of study for which they receive teach grants. So, what do I want to say here? We are proposing also in the consensus language that there will be an annual notice that the Secretary will send to grant recipients to remind them of the service obligation requirements, because it's important for grant recipients to be notified as they approach the date when they would be subject to a loan conversion, so that the grant recipient who has been teaching but has not yet submitted documentation of qualifying service would have time to do so in order to avoid that conversion. So we are proposing that in the consensus language, that a secretary will notify grant recipients in advance of the final date by which they must submit documentation of qualifying service to avoid loan conversion, and describing the information that the secretary will provide to a grant recipient whose grants are converted to loans, including the process by which a grant recipient may request reconsideration of that conversion. Providing that if a grant recipient's teach grant was converted to a direct unsubsidized loan, the secretary will reconvert the loan to a teach grant if, within 1 year of the conversion date, the recipient provides the secretary with documentation showing he or she is satisfying the service obligation. And also providing that if a grant recipient's teach grant was involuntarily converted to a direct unsubsidized loan, the secretary will reconvert the loan to a teach grant based upon documentation provided by the recipient, or in the case that the department's records that demonstrate that the recipient was satisfying the service obligation as described, or that the grant was improperly converted to a loan. So we've made it much easier administratively for everybody to comply with these requirements that show that a student has actually been completing their service obligation. We will also be specifying the actions that a secretary will take if a grant recipient who requests reconsideration demonstrates to the satisfaction of the secretary that the teach grant was converted in error, and the actions that the secretary will take if the grant recipient does not demonstrate to the secretary that the teach grant was converted in error. So that kind of completes the teach grant portion of the presentation. I want to talk about the faith-based entities proposals, again in general. Initially, the faith-based are slightly different because while there is consensus language on this, there are also some final regulations that came out on this. So I want to break that up into what's consensus and what's now final. If you had gone to the federal update, you know there was some conversation about that in response to a Supreme Court case decision in Trinity Lutheran Church of Columbia v. Comer and the Attorney General's Memorandum on Federal Law Protections for Religious Liberty relating to Executive Order 13798. The department ended up reviewing all of its Title IV regulations to see whether the rights of faith-based institutions under the Free Exercise Clause of the institution are or could be inhibited by regulations, and also for student eligibility for benefits under the regulation. So these are some of the proposals that came out of that. These are consensus language as opposed to final regulations. In the consensus language, it is proposed that we would delete outdated regulatory language that presumes members of religious order have no financial need for purposes of determining eligibility for Title IV programs. We would modify provisions that prohibit institutions from providing work, study, employment involving construction, operation, or maintenance of a facility for sectarian instruction or worship, and replace existing regulatory provisions with statutory language to clarify that the department takes a narrow view of the statutory provision. Loans made before July 1, 1993 actually include deferment benefits for full-time volunteer work, but the current regulations do not allow borrowers to obtain these benefits if their work includes providing religious instruction, conducting religious services, proselytizing, or fundraising in support of religious activities. These provisions are proposed to be deleted in the consensus language. We also have consensus language that proposes to modify provisions relating to the provision of gear-up services at private religious schools to make the provisions apply to all private schools. That is to say, the employment must be independent of the school and any organization affiliated with the school, regardless of whether those organizations are religious in nature. And we would delete language in the gear-up regulations that prohibit a partnership grant from having a fiscal agent that is considered pervasively sectarian. As I mentioned before, there were some final regulations that apply to the religious-based entities that were published November 1, 2019. These were published when we were basically the accreditation and state authorization of the distance education regulations, but these were also included. So in these final regulations, accrediting agencies are required by statute to respect an institution's religious mission, and the final regulations provide direction to agencies regarding this requirement and are intended to acknowledge the pervasive impact that a religious mission can have on campus while allowing an accreditor to require a comprehensive curriculum. Religious mission is defined in these final regulations and are defined as a published institutional mission that is approved by the governing body of an institution of post-secondary education, and that includes, refers, or is predicated upon religious tenets, beliefs, or teachings. And finally, the final regulations allow institutions to seek another accreditor after an adverse action if the action was the result of the agency failing, when I say agency, I mean accrediting agency, failing to respect the religious mission of the institution. The final regulations also clarify that the department recognizes the legal authorization of an institution with the religious mission to operate when the institution is exempt from state authorization under its state constitutional law. And for those of you that attended the state authorization distance ed piece, you've heard a little bit about that. So where are we time-wise? If there are questions, there is a microphone. The request is always that the questions be general. If you have specific questions, those are better reserved for a more case-by-case conversation. And if there are no questions, I know this is a really big room. Have you all been hearing an echo? You have been? I hear it up here a lot, so yeah. I don't know why they gave such a giant room when we knew this was not going to be, it's a very specific kind of group that would go see this presentation. But if there are any questions, please feel free to address the microphone, and if not, then I thank you very much for coming.
I may have missed it, but is the nationwide listing going to get updated? Last I saw it was from like 17, 18.
It should be. There's been a change in how the states are reporting this. There used to be a paper process, It is no longer a paper process. So now you have to go online. Have you checked online recently?
Yeah, I tried finding something about a month ago.
Okay. If you wouldn't mind sending me an email about that. I know there's supposed to be an update, but if it's not up there, I don't know why it wouldn't be, unless there's been some sort of another. Are you going through, are you looking just through Internet Explorer? Are you also using Chrome when you try to find that?
Primarily Chrome.
Pardon?
Chrome.
Okay, so you are using the one that we know works. And there hasn't been an update. Okay, so it should be coming fairly soon, but again, feel free to send me an email and I can get you the exact dates for that.
Thank you.
Sure. Yes.
So when do you think the proposed changes will take effect? I might have missed that.
So what we were talking about today, with the exception of the very end when I pointed out the final regulations from November 1, this is consensus language. What that means is that this is the language that was agreed to by the negotiating committee back when we negotiated January through April of this year. The notice of the proposed rulemaking, which is where we will formally propose these consensus language proposals, has not yet been published, but we expect it to publish very soon. Very soon. At that time, there will be an opportunity for the public to comment in regulations.gov on these proposals that were provided through the negotiations that we did back in January through April. So we cannot actually discuss them in a commentary kind of way since we haven't officially proposed them yet. What we can do is present, which is what we've done, what was provided as consensus language from those negotiations, and then let you know that we are anticipating very soon that there will be a notice of proposed rulemaking.
Okay, and I have a second question. So if a teach grant is converted to unsubsidized loan, does that have any bearing on future?
I'm getting a lot of echo.
Can you hear me?
Okay.
If a teach grant is converted to an unsubsidized loan, does that have any bearing on future eligibility for teach grants?
If a teach grant is what?
If it is converted to an unsub.
If a teach grant has been converted, in the consensus language, depending on the reason for the conversion, there will be a process provided that a student can utilize to have the teach grant that was converted reconverted. That process will exist in the new proposed regulations. Is that what you're asking me?
No. So let's say it was for a bachelor's degree and it was converted and now they're going for a master's degree. They want a teach grant for a different degree level.
Okay. So the teach grants that are for a master's degree have different requirements than the teach grants for an undergraduate degree to the extent that that's for a different academic level. The master's degree, under the proposed consensus language, the master's degrees sit in one bucket of grants and all of them, no matter how many masters you dealt with, and all of the undergrads sit in one bucket, but they're different buckets. So I don't know. We could talk about more specifics if you like. If you have that information, I'm happy to I think that's it. Thank you for coming.